Well, welcome, Shelli. Delighted you're here. There she is, right in the middle of the screen. I see you. Okay. George, you want to make an introduction?
Yeah. Today's guest speaker is Shelli Strahle, attorney, trust, wills, and estate planning. I'll give you some background about Shelli. I've worked with Shelli several times, and she's a delight to work with and really knows her stuff. So I thought she'd be great to invite to do a presentation for us. She's a graduate of the University of Pacific McGeorge School of Law with honors, received a Whitkin Award for academic excellence in international trade law and development, excelled in estate and gift tax law, speaks French fluently, and attended the University of Paris Sorbonne Law Abroad program. I thought about asking her to do the program in French and we'd do subtitles, but then I thought better of it. She's also executive member of the solo and small firm section of the California Lawyers Association, a member of Wealth Council, the Santa Cruz County Estate Planning Council, the Santa Cruz County Bar Association, the Advocates and board member of the Santa Cruz County Women's Council of Realtors. Today, she'll be talking about revocable living trust, durable powers of attorney, healthcare directives, probate, trust administration, pet trusts, and Proposition 19. And with that, I will turn it over to Shelli.
Thank you. And then do I have the ability to screen share?
Yes, you do.
Yep.
I will set that up right now.
Perfect. All right, here we go. Okay, so I'm going to give a basic introduction to estate planning, and I have a lot of topics to cover, so I'm going to go pretty quickly. So if you guys have questions, if you haven't, I guess would be better, write down your question, and then I'll answer them all at the end, since I think you guys are muted.
You can type them into chat,
and
I'll share them.
Okay, perfect. That'll work. Okay, so getting your ducks in a row. There we go. So I'm Shelli Strahle. I'm an estate planning attorney locally, and I run my own office, but I am part of Wealth Council. It's a national organization. Just some legal disclosures. No attorney-client relationship is formed through this presentation. And if you're having any issues relating to real property assessments, you should go directly to the assessor, because everything is on a case-by-case basis, and you should seek legal advice. Okay, so I'm going to go through some little hypotheticals. So I'd like you to meet Martha Stewart and John Stewart. They met, fell in love, and got married. They have minor children, so it's not only the elderly who need estate planning, it's also anyone that owns real property or has minor children. So they end up having a daughter. She grows up to be 7 years old. So they're a young family with one minor child. They have a home in Santa Cruz, a home in Florida. They have 2 bank accounts, a few stocks, and 1 life insurance policy. They take advantage of Kristen's spring break to go on vacation in Tahoe. This is back before they had to wear masks. The Stewarts die in an avalanche. What happens to their assets and what happens to Kristen? So hypothetical number 1, the Stewarts die with no estate plan in place. So this is the Stewarts' plan for the future. Well, when you have no will and no trust, you die intestate. So if your estate is over 150,000, and in determining that 150,000, they use the fair market value of your house. So they calculate all the assets that pass without beneficiary designation. And if that value is over 150,000, then the estate goes into probate. And because they died intestate, the estate is going to be distributed according to intestate succession. So they're going to look at whether there's a surviving spouse, whether there are surviving children. If there are no children, were the parents alive? If the parents aren't alive, are the siblings alive? If the siblings aren't alive, then they're going to see if the nieces and nephews are alive, and they're just going to keep going out. So that's intestate succession. So a lot of people that don't set up estate planning, if they have a falling out with a child or a parent, sometimes people end up inheriting that they wouldn't otherwise want to inherit. So in this case, they had a daughter who survived. She's a minor child, so she'll need a guardianship of the estate and a guardianship of the person proceeding. So the real property, the bank accounts and the stocks must be probated. The estate is valued at 1.5 million. Probate fees will be in excess of 56,000. So probate starts at 4% of the gross estate, which is why many people set up living trusts, because they want to avoid that process. So we're going to go a little more in depth about that. Also, Kristen is a minor child. So even though her parents had life insurance, she won't have access to the proceeds because she is a minor. So they have to wait until the guardianship of the estate proceeding goes through. Also, you should consider when you're purchasing life insurance, have you purchased sufficient coverage? So is it going to be enough money to support Kristen when the parents are gone? So negative aspects of dying intestate. The state decides who will raise orphaned Kristen because they didn't nominate a guardian. Kristen will not have access to the money, including the life insurance payouts, because she was under 18. And the interesting thing about the guardianship petition, so when she does turn 18, she will receive all of the funds and she'll receive all of them outright. So I don't know if you guys can see the car, that's a Maserati. That's what Kristen bought when she turned 18 with all the money.
Good choice.
Good taste, but she's out of money. Negative aspects of dying intestate. Probate is very expensive. The fee schedule for probate is set by state law in California, so it doesn't matter which attorney you go to, it's going to be expensive. Probate fees start at 4% of the value of the estate, and the fair market value of the property at death is how the value of an asset is determined. So if you own real property in Santa Cruz County, probate fees are going to be very expensive. Also, the probate process is long, and during COVID, the courts actually shut down. So if you didn't have a living trust in place and someone passed away during COVID, there was no way to transfer the asset. And even now, I think they're pretty behind on the court schedule because of the delay back then. And then down here, I say if an attorney is hired to help with the probate process, probate fees are doubled. So what I mean by that is the executor can take 4% and then an attorney will take 4%. So if there's an executor fee and an attorney fee, you're basically looking at 8%. More negative aspects of dying intestate. For out-of-state property, because in this hypothetical, they owned property in Florida, there must be an ancillary probate for every state in which you own real property. So if you own out-of-state property and property in California, you're looking at multiple probates. Whereas if you have a living trust, there's just one trust administration where the successor trustee is located. If there's a transfer of real property to non-children, the transferees will owe property taxes at the reassessed value for the length of time that the property was stuck in probate. And we're going to get into Prop 19, but this is going to be a huge issue because now even when it's a transfer to children, if they're not keeping the property and if it's not the principal residence of one of the children, it's going to be reassessed. And so if that property is stuck in probate for a year, they're going to owe back property taxes at the reassessed value. And we'll go more into Prop 19 in a little bit. So as I mentioned, probate court was closed because of COVID-19. So there was no way to transfer assets. It's running again and the proceedings are going through Zoom. So only joint tenancy property, community property with right of survivorship, and trusts avoid probate with real property. So the joint tenancy and the community property is a good way to transfer between spouses, but there's no, if you hold it that way, there's no way to transfer to the children after without avoiding probate. The other huge thing to know is that if you go on Medi-Cal, so not Medicare, but Medi-Cal, which is income-based, after age 55, and your estate ends up in probate, the state can come back for reimbursement for every dollar they paid out. But if your estate avoids probate by having a living trust, the state is barred from reimbursement. So even if you're able to qualify for Medi-Cal, you want to make sure that you shield your assets if you do own a home, because the home doesn't disqualify you from Medi-Cal, but they will take it if it's not in a living trust. So positive aspects of dying intestate, you do not have to contemplate death. So look how happy they are on the edge of the Titanic. So hypothetical number 2, the stewards die with a valid will. So it's fairly similar to dying with nothing in place, but a will, you actually decide who gets to have your property. A will is also a document that takes effect at death. So you'll hear people talk about how they are the heir of a will. Well, they are not an heir of a will until someone dies. So it has no legal effect until someone passes away. And then the will has to be proved, they have to prove it in probate court. So probate actually means to prove the will in Latin. And so if you prove that that was the valid will of someone, and there are wills that you can sign in front of 2 witnesses, or there are it's called a holographic will, where it's entirely in your own handwriting, and then you don't need the witnesses. If you notarize a will, it is not valid in California. So you need to follow the legal formalities of California. If you do follow the formalities, then it will be lodged and it will be admitted into probate court, but it still goes through probate. So you're still going to be subject to the fees of probate and all the other things that I talked about for probate. But the huge difference here is that the estate will be distributed according to the will. So in that scenario that I was telling you, where if you had a falling out with a person who would normally inherit under intestate succession, this way you could cut them out. And then Kristen is a minor, so this time they could nominate a guardian, but they're still going to have the issue of her being a minor and not having access to money. So a will must be probated. Probate is expensive, long, and public. So that's the other thing, is that living trusts are private other than the real property deed where you transfer it to trust, but the actual trust doesn't get recorded anywhere. Whereas probate is a public proceeding. It also allows creditors to come in, including the Department of Healthcare Services for Medi-Cal recovery. And Kristen will not have access to any money. And so again, we have that same problem that when she turns 18, she's going to buy the Maserati. Positive aspects of a will. So you get to determine who receives your property. You get to nominate a guardian. And then a will package comes with incapacity planning, which we will discuss. So hypothetical number 3, the stewards die with a valid trust. So this time they die with a living trust. A living trust is a document that takes effect during life. A trust designates a person who is called the trustee to hold legal title of the property and the trust for the beneficiaries. So usually when you set up a living trust, you are the trustee of your own trust during life, and then you choose someone that takes over at death or during your incapacity. Trusts avoid probate. So that's why people like to set up living trusts, because they don't go through that court process and they save their family a lot of money. The other thing is that it's not subject to reimbursement by the state if you go on Medi-Cal, so it shields it from that. And then a really big difference when there are minor children involved, when you have an adult trustee, if there are life insurance proceeds or retirement plan proceeds, they can list the trust and then it will pay out because it's paying out to the adult trustee. So, and then when you have an adult trustee, you can also list that the money would, Kristen wouldn't get everything at 18. She could get it at 23 or at 25 or whenever the parents decided. So she wouldn't get the Maserati in this case. So negative aspects of a trust, not very many negative aspects. Some people that set up trusts a long time ago, the trusts were set up as an AB trust, or it's sometimes called a survivor's trust and a decedent's trust. And the language was that it shall split upon the first death. That's when the estate tax was really low. Right now under Trump, it's over 11 million per person. And when you file on the first death, you get your spouse's exemption. So pretty much, and with discounts and everything, you need about 25 million before you owe estate tax in the current administration. Biden does want to lower it to 3.5 million per person, and you'll still have that filing. If you file on the first death, you'll get your spouse's exemption. So it's still going to be pretty high under, and that's just what he's proposing. Back when Obama came into power, he proposed something similar, and then it ended up being 5 million and 10 million married. So we'll see where it actually ends up, but it's still pretty high. So anyway, if you have a trust that's set up as an AB trust, if it's just a little nuclear family, husband, wife, kids together, there's no concern about disinheriting stepchildren or anything like that, you may want to have your trust looked at, because if someone dies and it's set up with this old language for estate tax, it can be a very big burden on the surviving spouse. And then it's also going to have negative income tax consequences for the kids. So definitely have your trust looked at if you haven't had it looked at in a long time. The other thing is that older trusts are unlikely to be properly funded. So trust funding is when you make sure that your assets that have title are titled in the name of the trust. So a lot of people come to me to look at trusts to see if they need to change any of the language, and we find out that they don't have a lot of accounts in trust, or they refinanced or did something with the property or bought a new property and the property is not actually in trust. Also, if you have a mobile home, it's dealing with the Department of Housing, so sometimes that doesn't happen either. So positive aspects of a trust: Martha and John get to determine who will receive their property. The trustee of the Stewart's Trust will have immediate access to funds, and it will be administered to Kristen privately and dispersed to her over time. They could structure the trust so that her disbursements don't affect financial aid for college, which is big because they could have it go to her after. And a trust, most importantly, a trust avoids the probate process. So that's saving your children potentially $50,000 to $100,000, depending on the value of your property and accounts. And trust administration usually takes less time than a formal probate, which can lead to massive savings in property tax if the property is going to non-children, and after February 11th, 2020, also to children if it's not going to one child as principal residence. More positive aspects of a trust. So there will only be one trust administration and not two probates because they owned property in Florida. So a trust is administered where the successor trustee is located, or if, let's say that the successor trustee was located in Missouri, that depending on how the trust is worded, if it requires California law, they can hire a California attorney and they can still handle everything from that other state. Or they can actually, if it doesn't require California law, they can even choose to administer it in that state. But it'll only be one trust administration, which is a big difference. Because Kristen's parents had a personal property memorandum as part of the trust package, she can focus on grieving instead of fighting over couches. So some trusts, my trusts, are trusts that have this, but it's a personal property memorandum, and it's something that you can list. So personal property is tangible stuff in your house. So the things in your house, your animals, even your vehicles, they're considered personal property. So you don't have to go to an attorney to update if you want someone in particular to get something. So it's something that it's automatically incorporated into the trust. A trust comes with incapacity planning, just like a will package. If the Stewarts were in the process of selling a home when they died, the successor trustee could continue the sale. With no estate plan in place or a will, the property would be stuck in probate. So that's another advantage to having a trust, is if there's any type of sale process happening, it can continue, where the sale is pretty much dead in the water if you have a will or no estate plan. Trust funding, we went over that a little bit. I just want to make sure you understand what that means. So funding a trust means changing title of the trust property from the name of the person to the name of the trust. So before, John and Martha Stewart owned their property either as John and Martha Stewart as community property or John and Martha Stewart as joint tenants. Here, they would transfer it to John and Martha Stewart as trustees of the John and Martha Stewart Living Trust, dated whatever month, day, year they signed the trust. They have a pour-over will and a general assignment. So if you have an updated trust schedule, a pour-over will, and a general assignment, even if we find out after you die that you didn't have your house in trust and you didn't have your accounts in trust, an attorney can get a court order and avoid probate anyway if you have those documents. If you don't have the general assignment and you didn't keep your trust schedule up to date, then it might be denied. But if you have all of those documents, it's okay if you didn't properly fund the trust. Hypothetical number 4, Martha loses mental capacity. And while she lost mental capacity, she didn't lose her balance. So will and trust packages provide incapacity planning. So in this case, because she had a power of attorney for finances and a power of attorney for healthcare decisions, and in California that's called an advanced healthcare directive, Martha would avoid conservatorship. So conservatorships are very expensive and they can create unnecessary delays on medical decisions and financial matters. So before you lose capacity, you have to choose who your agent would be for healthcare and for finances. So if you wait until you cannot sign a power of attorney once you've lost capacity. So you have to sign it ahead of time, but you can have it where it doesn't take effect until you lose capacity. So like I said, when you have an advanced healthcare directive and a power of attorney, no conservatorship is needed. Another alternative to the advanced healthcare directive is a document called 5 Wishes. It's a little more in depth than the healthcare directive if you felt like the healthcare directive wasn't enough, but you choose one or the other. And an advanced healthcare directive nominates a person to make decisions for you in the event that you're unable to communicate your medical wishes. A power of attorney is a document that gives a person the authority to act as the agent of your finances. You can choose whether you want it to be springing or immediate. If you want it to be springing, it takes effect upon an event in the future. Usually that's 1 or 2 doctors declaring you incapacitated. If it is immediate, you don't have to go to a doctor. So your agent would be able to act immediately for you. Okay, so some people think they're going to be tricky and add a child on to their property as a joint tenant. They think, well, I'm not going to pay money for a trust. I can just add my child on as a joint tenant. Well, there's a lot of problems with that. So one thing is that the transfer cannot be undone. So if you have a falling out with that child, or for some reason you need that child off title, it's permanent without them signing off. The other issue with this is after Proposition 19 goes into an effect, which officially is February 15th, 2021, but there's a holiday, so February 11th, 2021 is the real deadline. Reassessment, if you're not, so under it says my connection is unstable. Hopefully you guys can hear me. So Proposition 19 basically gets rid of Prop 58, the parent-child exclusion, unless it was the principal residence of the deceased and it becomes the principal residence of the child that it's going to. And there's a limit of 1.2 million fair market value. So before, the principal residence was unlimited and you had $1 million of assessed value of other property. Now, if it's other property, not the principal residence, there's no parent-child exclusion for property taxes, and there's quite a bit of restriction even on the principal residence. So in this case, if you're trying to transfer to your child to avoid probate, that's a transfer. If it's after February 2021, and you'll be reassessed on that transfer unless you can show that it's also the child's principal residence. So, but even now, when Prop 19 isn't in effect, there are issues because you can't undo it. The other thing, if your child has a creditor, and it may be an unforeseen creditor, it may be that they owe child support, it may be that you're subjecting your house to a divorce, they may cause a big car accident, so you're risking your asset if you add them on title. The other huge reason that it's a good idea to not add your children to title is that you don't get the double step up in tax basis. So when you have a living trust, and if it's structured in a way that it's not a forced split on the first death, like those old trusts were. So if you've updated the tax language, then you get a double step up. And so when you and your spouse pass away, they'll calculate, for income tax purposes, they'll calculate the value of the property at death. And so if your child sells a year later, they'll only have a year of capital gains versus whatever appreciation during your lifetime that you had. But if you add your child on as a joint tenant, they're going to lose half of that step up. So for income tax purposes, it's not good either. So let's talk a little bit about property tax. So I mentioned, so Prop 13 is where you got to keep your property tax rate. Prop 58 is where it passed the Prop 13 rate from parents to children. Prop 193 is where you could pass it from grandparents to grandchildren if the parent was deceased. So before, it was for the principal residence, in all circumstances, you could pass that. You'd pass the Prop 13 rate. And it was passing the assessed value, and they were calculating everything by assessed value. And then you'd have $1 million extra beyond the principal residence, and that was of assessed value. So Prop 19 completely gets rid of the parent to child exclusion. So you can't keep Prop 13 for any non-principal residence properties, because it has to be the principal residence of the deceased. And then it also has to be the principal residence of the child. So that's going to bring up a lot of issues of, if you have multiple children, do you need to amend your trust to make it go to one child if you know only one child is going to take the property? If not, they're going to have to get a loan to show that one child was getting the property and one child was getting an equal amount of money. Otherwise, they'll reassess on the portion that gets transferred, because they consider it a sibling to sibling transfer. So it's going to be really tricky. The other thing is, if you go into a nursing home and the property is rented out and it's no longer eligible for the homeowner's exemption, it's going to be really tricky on whether, so there's going to be a lot of new sort of loopholes where they can try to reassess and vice versa. So it's going to be interesting. The other big warning that I want to say is, a lot of people, when Prop 19 passed, they're rushing out and they're adding a child on now, or they're gifting property now. So that's a good idea if you know that your child is never selling the property, because then they get to keep that property tax rate if you do the transfer before February 11th, 2021. But if they're selling the property at some point, or they're not sure, you're going to lose that step up in tax basis. And so you have to be careful that might cause more tax consequence for them than you actually are saving them in property taxes. So it's a good idea to check in with an attorney before you do anything on your own. And that's my seminar. So if you guys have any questions, and I'm going to stop my screen share. Let's see. Okay. Oh,
I have a question. Hi, my name is Jack.
Hi.
Hi, thanks for this presentation. This is great. We've got the whole suite of documents, but one thing that confuses me is advanced healthcare directives. I've heard that if you're in the hospital and you need your spouse or somebody to make decisions for you, that sometimes the doctors and hospitals won't accept it, that they'll make you sign their documents. Is that true? Does that become cumbersome?
I know that when you don't have something, but I haven't heard them not accepting a healthcare directive. What I usually recommend for my clients is, long before it's a hospital emergency, that you actually take your healthcare directive and get it on file with your, if it's Kaiser or PAMF, they'll put it on file. So then you'll know if they accept it or not. But
Okay.
if you're coming in with your own document. The other thing too is that not everyone uses the current healthcare directive. A lot of people will come to me and say, here's my healthcare directive, and it's from like 1985 on an old form. So that could also be a possibility, where they're saying you need to fill out our new form because maybe it's really old.
Mm-hmm.
So
okay.
Every so often they update what is the current form. So.
Right. Thank you.
Mm-hmm.
I have a question about, oops. Yes, no?
Yeah, go ahead. I think someone else is trying to talk, but she was muted, but you go ahead.
Okay. I think it's an easy question. So I have a reverse mortgage on my residence, and someone told me that you cannot put it in a trust when you have a reverse mortgage. Is that true information?
That is not true. So It depends
Good.
on the company. So a lot of times what happens is you'll need to submit documentation to them and they'll want to look over the trust. And a lot of times they'll want a letter from the attorney stating follows everything that you need. They want to make sure that it's not irrevocable, that it doesn't have any language that would be adverse to their interest. Oh,
Okay. So
Uh-oh.
so the answer basically is it
oh,
depends.
there. Okay.
Oh, okay. Thank you.
Yeah, so it's not necessarily it depends. The answer is you can have a trust when you have a reverse mortgage, but you have to give notice to the company, and you're going to have to give notice in the way that they want.
Can I ask a question about the 5 wishes again?
Uh-huh.
So alternately, you said that the healthcare directive or the 5 wishes can be used?
Correct.
Okay, all right.
Yeah, and then so it's the healthcare directive or the 5 wishes, but I don't know if you're familiar with the PULST. That's like the bright form. That one can work with 5 wishes or the healthcare directive. So you can have a PULST and a healthcare directive, a PULST and a 5 wishes, but you should have a healthcare directive or a 5 wishes.
And what is that you said, a PULST?
A PULST, yeah. So it's a form, you can only get it from a doctor, and it's a bright form, and it's actually a form that you would put on your fridge for emergency personnel when they arrive.
How do you spell it?
It's POLST. And
Okay.
it stands for something. I'm not sure what, and you can get it directly from your doctor.
Okay, thank you very much.
Sure. Any other questions? Oh, also, I wanted to say I do offer complimentary consultations too, if any of you had questions about your own estate plans.
Can you go over what the 5 wishes is?
Yeah, so it's a document that I believe it's a national document, but it is accepted here, and it's basically a healthcare directive that goes into much more detail. So you get to talk about whether you want music, and it's just going to go very, very in depth, whereas the healthcare directive covers basic decisions like you don't want to be unnecessarily prolonged, you do want to be an organ donor, you want cremation or burial. So it's very, very, very basic, versus the 5 wishes that it prompts you to get more detailed with the question. So if you want to get much more detailed, then the 5 wishes might be a better way to go.
And
You
where can,
recommend setting up a survivor's trust after the first spouse dies?
I'm sorry, can you repeat that question?
Do you recommend setting up a survivor's trust after the first spouse dies?
So that depends entirely on how your trust is written. So that's a really loaded question. So possibly, but in the trust that I draft right now with the current exemption, the survivor's trust, well, yeah, so most trusts, they always have a survivor's trust and another trust. So what the question is, are you going to put everything in the survivor's trust, or are you going to split it into 2 trusts? And if you don't have a taxable estate, it's not good for income tax purposes to split into 2 trusts. So,
Okay.
but I'd say you'd want to check in to make sure you have current tax language. Someone wrote, can you put an annuity? Sorry, I'm going to answer the question that was posted. So they said, can you put an annuity in a trust? You can. I mean, you can have it pay to a trust, but annuities and life insurance, if you have adult children, there's not really any benefit to putting in the trust because you can just list named beneficiaries. So I usually just recommend for adult children listing the beneficiaries outright, or if you wanted to list charities, you could list them outright. I'd say maybe there could be some benefit if you're doing some sort of charitable remainder trust, if you were trying to not have capital gains on something. But in general, I mean, yes, the answer is yes, you can put an annuity in a trust, but should you? That's another question.
Shelley, I have a question.
Mhm.
We need to make several changes to our living trust of maybe 8 years ago
Mhm.
because the children are grown now. And so there's some changes that need to be done. Do we have to go back to the original person who did it over in Los Gatos?
No, no. So if you're doing a restatement, it completely replaces the original trust. And then anything that's properly titled, you don't have to retitle it again. So if your house is in trust or you have some investment accounts in trust, you don't have to retitle those, but you can change everything you want. And a restatement is also kind of nice because an amendment to a trust, you're having to go back to the original trust language and figure out what has been changed. A restatement just starts fresh with new content on the document. So it's I think it's less confusing for the heirs. Also, if that attorney kept the original trust, that doesn't matter because you're completely replacing it with the restatement. But no, you're not obligated to ever go to the same attorney if you're wanting to make changes. And in my practice, I give the originals to the client so that they, like, if something happened to me, I don't want them to be in trouble with not having the originals.
Vicky, you had a question?
Thank you, Dave. Hi. If you name your successor trustees in your trust, and then you also in your will have shown that they are the heirs of your real property, can they decline to be successor trustees and the heir to the asset after your death?
Yeah. So one thing though, when you have a trust is the will serves as a pour over will. So they're going to inherit through the trust. If everything's set up properly, they're not going to inherit through the will. If they're inheriting through the will, that means there's some sort of issue and you're having to use that. So, but yeah, you can have them be the beneficiary of a trust. And if they don't want to be the trustee, they can just resign. And so if they resign, if you have another person listed, it will go according to your list. And then hopefully your trust deals with default of designation, where if you've run out of everybody on your list, then it says what happens. So generally the beneficiaries can appoint someone.
Okay, thank you.
And then I have some more questions that were written. Let's see. If no children, would a will plus transfer on death documents for assets be sufficient? It looks like Susan asked this question. So that depends on your assets. So I have lots of clients with no children that set up a trust because they don't want the people that are inheriting to pay probate fees. So if you have over 150,000 in assets, then it's still going to end up in probate, even if it's a friend that you're listing who inherits. So it just depends on whether you want those people to go through the probate process. So I have many, many clients with no children that have a trust. But if you have under 150,000 in assets and you just have transfer on death assets like TOD accounts that are transfer on death, or maybe you have an investment account that allows beneficiaries, or retirement plans, or life insurance. So if you have under 150,000, then, and you can structure everything to pass on death, then yeah, I think it would be okay to not have a trust. But if you have over that amount, it really just depends on if you want whoever is inheriting your property, if you want them to suffer through probate. And then the next question is, should a will be made by the same attorney as a trust? Oh, I think that was answered already. It doesn't have to be. So, should a will be made? So anytime I set up a trust for someone, I draft a pour over will. So it's not, a will doesn't have the same effect as a will by itself. So all the will really does is it says, I pour over all my assets outside of trust to the then acting trustee of my trust. So a will is a little different when you have a trust. So if you had a will and a trust that were both trying to give your property, then you'd have to look at which one was done last and it would cause problems. So you always want the will to be a pour over will. Any other questions?
Shelly, this is Pirat Harman. Were you saying that even those assets that have beneficiaries named, such as maybe investment accounts or bank accounts, they go into probate if
No,
they
so,
don't?
so assets that have named beneficiaries avoid probate. So probate is the process to determine where assets go. So if you have named beneficiaries, then that by definition avoids probate because you know where that asset goes. But the one thing with named beneficiaries is you always want to make sure that your beneficiary designations are up to date. So if you have a daughter and she got married, you want to make sure you update her name. Sometimes people, when they get these assets, they list spouse, but they never list alternate beneficiaries. So you want to make sure that you always have alternate beneficiaries listed as well.
But they don't necessarily have to be transferred into the trust.
No.
Okay.
If you have named beneficiaries, the only time I recommend putting those assets in trust is when you have minor children, because you don't want them having access to the assets too early. And then also they won't be able to get access when they're minors. But if you have adult children, then you can just list named beneficiaries.
Great, thank you.
And then I have another question. It says, it's kind of, I think I kind of answered this. It says, is it advantageous to have a will and the trust be made by the same attorney? So yes, because I mean, the will is it's almost nothing. It's just a document that says I pour everything to my trust. So as long as it's a valid pour over will, that's the one thing though, is anytime you amend your trust or restate your trust, you always want an updated pour over will, because that's what the court will look for if you have any assets that aren't properly in trust. They'll want to make sure that you have a pour over will that shows that you amended or restated. Any other questions?
Shelli, I have a question. I'm not clear about the pour over will for new content. Is that specifically for new content? The pour over will?
So if you create a trust and then let's say later you decide you want to change your list of trustees, so then you make an amendment to your trust, you always want to update your pour over will, because the new pour over will say, I pour over all assets outside of trust to the then acting trustee of my trust, dated blah, 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 as amended on blah, 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 whatever date. So it always mentions the amendment, or if you restated it, then it'll say restated on this date. So that's what courts look for if your assets aren't properly in trust.
But you said it changes the trust entirely?
What changes the trust entirely?
Having new content.
If you get a restatement is basically getting a new trust. And yes, that changes the content entirely. If you get an amendment, that only changes the particular part of your trust that you want to change, but everything else stays the same. So it depends on what your goal is.
Oh, thank you for clarifying that.
Mm-hmm. Any other questions?
That's good. I know you got to run. Really appreciate it, Shelli. That was excellent information and very concise and covered all the points. So, and if you don't mind, we have recorded this Zoom meeting, so I can post it on our website unless you don't want me to, which would be understand either way.
No, that's fine.
Okay, great.
Oh, and actually, George, can you still hear me?
Yep.
One thing I did forget to mention, just because you mentioned it in the title, pet trusts. So I just want to say really quickly about pet trusts. So pet trusts are valid trusts in California. And the way that they work is you list a trustee who's in charge of the money for the pet. You choose a guardian, and that's the person that's actually in charge of the pet. And then you choose a remainder beneficiary. So if the pet passes away, it goes to a human beneficiary. So they're actually valid in California. And in some states they're honorary, but here in California they are valid. So I just wanted to cover that since you put it in the title.
I appreciate that. I actually know somebody I'm going to talk to immediately after the meeting about that.
Oh, well, there you go.
Yeah, thank you very much. So yeah, this is a great way to wrap up the year. This will be our last Zoom meeting for this year. and then we'll reconvene in January. But again, thanks a lot, Shelli.
Thank you.
And,
Thank you for having me.
Thank you.
Yeah, our pleasure. Yeah. So tune in to our YouTube, and we'll be posting. We have a lot of videos posted there. We'll be posting this one, and our next meeting will be on Monday, January 4th at 4 p.m. And we will discuss predictions, resolutions, fond memories, and future plans. And with that, you'll be able, we'll post the YouTube video, and it will have contact information for Shelli also. So, and with that, did you want to wrap up, Dave? Maybe go through the, like our beginning? We'll tack our beginning on the end and wrap up with there we go, about a little bit about our organization.
George, I think you covered it just fine. We look forward to seeing everybody on January 4th. We'll have a lineup for January of very interesting speakers again. We appreciate you being here today.
Thank you.
Thank you.
Thanks, everybody. Happy holidays.
Happy holidays.
Happy holidays.
Thank you.
Keep cozy and well.
Thanks for coming.